Thank you, Mr Chair. Look, the question's been raised about the urgency again, and I'm happy to address it again, and hopefully more to the member's satisfaction. I think it's, there's always options around this, and this is certainly not a step that I've taken lightly. But the advice has come to me in only the last few weeks or so that the situation could become quite serious, and that this is not something that we could leave for the normal select committee process. The House will be aware that this government hasn't taken urgency for some time, particularly which would give an opportunity for this. And I would actually think that this is exactly the sort of bill that should be going through urgency. I take on board the concerns that Mr Little has raised about, well, why urgency? Why couldn't we just put a start date in that is essentially retrospective to the legislation coming into force? That is absolutely an option. But what we're dealing with here are 60 finance companies, all failed. What is being achieved by that? I would be more inclined to do that, although I'm not someone who generally believes in retrospective legislation. For me, that is a very difficult step to promote. I think it inherently has issues, and particularly around process. But in addition to that, in this case, I was also given some comfort by the fact that this bill is only a stopgap measure. We do in fact have the Financial Markets Conduct Bill coming through the House through the normal process, and it doesn't come into effect until April next year, should it be passed by the House. And as the Green member Ms Genter raised earlier, will it be in contravention, or will be there any issues with it? Oh, no, I think Ms Dalziel did, sorry. Will it be in contravention of this bill? It will actually replace this bill. So it's really, this is very much a stopgap measure. If we were looking at urgency is often around issues that must be dealt with, and certainly in all stages, like excise tax issues where behaviours will change. I don't think I could trust frankly, that the lawyers for these failed finance companies, or rather the trustee companies, wouldn't charge off to court tomorrow to file proceedings under the existing law if they had the notice. We're not making this law for them. We're actually making this law for the public of New Zealand, the taxpayers and the public trust, who actually have done nothing wrong. Not a thing. They haven't done anything wrong. They weren't paid large fees to be corporate trustees. They didn't fail in their duty. They didn't mislead or do anything wrong. They are innocent bystanders, and frankly I don't think that we can risk having them put further to the test when it comes to the sort of litigation that would ensure. And yes, this is a test case we're looking at, which is due for hearing on the 6th of June this year. So we don't have a lot of time. And knowing the legal professions I do, and with the greatest respect for it, I'm sure that there are people right now preparing documents to be filed if this doesn't go through tonight. But I would like to thank, and take the opportunity again to thank the House for taking such a mature and responsible attitude to this legislation, which is entirely necessary.
Members, the question is that clauses 1 to 5 stand part. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. I will report this bill without amendment.
The House is resumed. Mr Chairman.
Mr Speaker, the committee has considered the Trustee Public Trust Amendment Bill and reports it without amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. As many of that opinion will please say aye. Aye. To the contrary, no. The ayes have it. This bill is therefore set down for third reading forthwith. I call the Honourable Minister Judith Collins.
Mr Speaker, I move that the Trustee